Bridget Mackay. I'm an attorney in Petaluma, California, and I practice in the area of estate planning and probate and trust administration. And this month, my video blogs are going to focus on gay rights. The Supreme Court argued or heard arguments this week regarding Proposition 8. And are going to make some big decisions in the court. It was in Time magazine. The British House of Commons approved gay marriage. So it's an up-and-coming issue, and what does that mean for same-sex couples is the question when it comes to estate planning. Married same-sex couples, registered domestic partnerships in California. And so this video blog is going to focus on one of the basic questions that a same-sex couple may have if you're married or you're a registered domestic partnership here in California prior to the federal potential rules coming down or common law coming down out of the Supreme Court is what happens if we don't have a will or a trust and one of us dies? What happens to that partner's property? If you are registered domestic partners in California, that spouse, the surviving spouse, is recognized as if you were a married couple, opposite sex married couple. And so any property that is community property, which is property you acquired during your registered domestic partnership or marriage, goes to the surviving registered domestic partner. All of their separate properties, so that's property they may have inherited, the deceased partner inherited, or had prior to the relationship or prior to the registration or marriage, will be, if there are children, will be split either 1/3 or or half with however many children of the deceased partners. So for example, if the deceased partner had 3 children, then the surviving partner would get 1/3 of the separate property and the surviving children would get 2/3 to split amongst themselves. If that deceased partner had 1 child, then the partner would split half and half with that 1 child. So that's sort of the basics of what, where do things go? And the process by which you would transfer those assets would be through a probate because there was no will. And, that's a court process, and that is no different than opposite sex couples would have to go through. If the property, let's say you own a house, and I often see in same-sex couples, one of the partner's name is on the house, but the other isn't, because they either possessed it prior to the registration or the marriage, or it was bought with separate property, then that would be considered separate property and would have to be split if there are any children. If there aren't any children of the registered domestic spouse, then all of that separate property goes to the surviving partner. So that's just a tip. If you have further questions about it, it's really important for same-sex couples to get counseled and get legal advice when they embark on making an estate plan, or if they haven't made an estate plan, what all of their property and the different way that they hold title means if one of them were to become seriously ill or pass away.